What's at stake as the Supreme Court takes this on? Part 3. The Supreme Court is now being asked whether freight brokers should keep a legal shield Congress never intended. When the FAA passed in 1994, the goal was economic deregulation, not safety immunity. No one argued that brokers should be protected from negligent hiring claims. That protection only appeared later through broad court interpretations that stretched the statute far beyond its purpose. Major industry groups, including the American Trucking Associations, ATA, the Transportation Intermediaries Association, TIA, the Intermodal Association of North America, IANA, and other large corporate shippers, pushed hard for wide federal preemption to limit state regulation and reduce liability exposure. Over time, those interpretations were defended in court, allowing brokers to avoid responsibility for the carriers they choose. Trucking became the only major industry where intermediaries use a federal law to avoid negligent hiring liability. In construction, real estate, insurance, staffing, and financial services, brokers can be held responsible for choosing unsafe contractors. Freight is the outlier not because Congress intended it, but because the FAA was expanded into something it was never meant to be. For decades, families were told they couldn't sue because brokers were preempted. States were told they couldn't enforce their own safety authority. The industry treated this as settled law even though Congress never debated or approved broker immunity. It wasn't settled. It was simply unchallenged until the people most affected refused to stay quiet. The push for change began with survivor families, victim advocacy attorneys, and national safety groups like Road Safe America, the Truck Safety Coalition, Parents Against Tired Truckers, Crash, and advocates for highway and auto safety. They documented unsafe hiring patterns, filed briefs, and kept the issue alive when courts shut the door. The movement grew as independent advocates, Justice for Truckers, SBTC, and many others publicly supported the effort, amplified the message, and stood with families demanding accountability. Their work highlighted a simple truth. This issue affects everyone who shares the road. That pressure is what brought 30 state attorneys general from both parties to the Supreme Court. They told the court that states have always had the right to protect people on their roads and that Congress never intended to remove that authority. Now the court must decide whether to restore the balance Congress intended or leave in place a loophole no legislature ever approved and no safety expert supports. This case is a test of whether safety still matters in a system that moves nearly everything Americans rely on.